and shine. Coffee's brewing, feeling fine. News is out and on the air. Shizzy Whiz nuts wild, but we don't care. Morning Whiz and Coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz nuts, start the show. Let's go. Did it get a hit? Yeah. Oh yeah. Headlines spinning in the breeze. Stupid jokes, he's such a tease. Sip the Java with a smile. Pants are off, but stay a while. Morning Whiz and Coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz, let's start the show. Let's go. Did it get a hit? Yeah. Oh yeah. Headlines spinning in the breeze. Stupid jokes, he's such a tease. Sip the Java, wear a smile. Pants are off, but stay a while. Morning Whiz and Coffee. Talk the news, he's a tease. Laugh it off, we're on the go. Shizzy Whiz, let's start the show. Let's go. Did it get a hit? Yeah. Oh yeah. Serious is overrated. Every day we're caffeinated. Talk the town, but in a jest. Morning Whiz is always best. Clock is ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop. Clock is ticking, time to run. Morning show's a load of fun. Grab your mug, don't spill a drop. Laugh your ass off till you pop.
Oh my god, Shizzy breaks Larry. Shizzy broke Larry.
Good morning, good morning. Good to see all you fine people this morning. Yes, Carola, that is exactly how that works. Leaderboard works and shows the rank of each viewer's engagement. The more engaged you are, the higher you get. The higher you get, the better it shows and you get points. And it sounds like fun. It sounds like fun. So good to see everybody this morning. Oh my gosh, do we have an interesting one for you this morning? I got one bit of news I got to get out this morning, and then we're going to get into the Laura Owens. Well, it's actually Gingris's filing to, well, it's not actually filed yet. It's just his proposed petition to the Supreme Court. But before we get into that, we are going to have a very interesting one. Hey, Debbie, good to see you. How are you doing? I agree. Tammy, BS. You guys are awesome. All right, here's what we're going to do first. Boulder terrorist is Biden-era migrant whose visa expired, but he didn't leave. Now, if you hadn't heard, there was a pew-pewing in Boulder, Colorado. The attacker Mohammed Sabri Suleiman screamed "Free Palestine" through Molotov cocktails at people who were peacefully standing for Israel in Boulder, Colorado Sunday night, injuring 8. Suleiman is a Palestinian activist who doesn't hail from any Palestinian area. Also, like Arafat, Suleiman is from Egypt. The Biden regime gave Suleiman a visa. He entered in the U.S. on August 27, 2022. By the time he carried out his attack, he'd overstayed both visa and work permit that the Biden immigration officials granted him later. Now, Fox officials reported Sunday that Suleiman first arrived in the U.S. after landing at Los Angeles International Airport on August 27, 2022, a non-immigrant visa very quickly thereafter. However, on September 9, 2022, he filed a claim with the U.S. Citizenship and Immigration Services. That may have been why he stayed in the country after his visa expired. Nearly 2 months later, on March 29, 2023, Biden rewarded Suleiman for violating the terms of his visa by granting him a work permit, which was valid for 2 years. That means by the time he started throwing his fireballs at elderly Jewish people and supporters of Israel, Mohammed Salbri was no longer authorized to be in the United States at all. However, if they had identified, apprehended, and attempted to deport him before they attacked, he could quite easily have become the Columbian University pro-Hamas agitator who became the hero of the left and darling the established media when Trump officials tried to deport him. He would have seen Chuck Schumer, Alexandria Cortez angrily demanded that Solomon be freed and weepy media pieces about the noble, heroic fellow that Solomon is. Summed up, the fiasco is that the Biden administration granted an alien a visa, then he allegedly overstayed. They gave him a work permit. Immigration security is national security, no more hostile migration. Keep them out and send them back. He added a terror attack was committed in Boulder, Colorado by an illegal alien. He was granted a tourist visa by Biden's administration. Then he illegally overstayed that visa, and in response, they gave him a work permit. It was a very, very bad scene. So this is very heartbreaking and saddening. I saw this last night, and I didn't get to it because I didn't see a good spot for it to come out. But it's pretty sad that this man injured so many people, and very, very sad that happens. And the legislature's on still. That is a big possibility. But we do have a very interesting bit today. So we're gonna read over this particular document, and it is so interesting because I also have a letter. You don't normally get those in the morning, but you're going to get one this morning. Now, this was filed. Well, it hasn't been filed yet. It might have been filed by the time that we're reading this, but it seemed like Ingress was trying to make something out of nothing here. So, issues decided by the Court of Appeals as presented for Supreme Court review. And this is a very long document, so we won't get through it all today. Oh, yeah, you'll get a letter today. Can a family court impose $150,000 in sanctions for a violation of Family Law Rule 26, the family court equivalent of Civil Procedure Rule 11, without following any of the mandatory safeguards in Rule 26C, prohibiting sanctions unless the moving party first personally meets and confers, followed by a written warning in a 10-day period within which the opposing party may withdraw or appropriately correct the alleged violations, which we already know. We already know, if you weren't following this, that the party never withdrew. They never withdrew their sanctions on there at all. They never withdrew the lawsuit against Clayton Eckert. If you don't withdraw, you're going to get your ass in trouble. And that's why it ended up where it was. So if a party is threatened with sanctions for violating Family Rule number 26, and if the alleged violator responds, here, I'll make this a little smaller just because it was hitting the borders there. If a party is threatened with sanctions for violating, and if the alleged violator responds by invoking the safe harbor of that rule by moving to dismiss the offending pleading with prejudice, can the family court refuse to allow the pleading to be withdrawn, then impose $150,000 in sanctions for fees incurred after the violator moved to dismiss the pleading with prejudice? In other words, when a party is accused of filing a pleading that violates Rule 26, can a family court block that party from invoking the safe harbor, then sanction them for the same pleading they attempted to withdraw? Like I said, you had to have withdrawn first. And it goes on through this right here, and then it's just basically asking these questions to the court, because see, whenever Laura Owens lost her family suit that she was filing suit against Clayton Eckert, she kept claiming that she was pregnant at the time, completely at the time. So her lies got caught up with her. Yeah, she needs to be in a padded jail cell. That is a big possibility. That would be for her either adjudication or incarceration, because she's looking at some serious time and the shenanigans that she played. Now, you have to remember, if you back all this up, this all started whenever she decided to stalk someone out. Sounds familiar, doesn't it? And get close to them. And here's the thing that where I sort of draw some of these parallels. We've seen this kind of document come through. Hey, welcome on Real Aussie. Good to see you. Morning. So you have to remember that all of the screaming that you're hearing coming out over on the anti what the hell's little groups over there. A lot of the screaming that you're hearing is, well, you know, we're not attacking Jeremy. We're not doing anything. And in, you know, some cases, it might be that they're using a little bit of free speech, but in other cases, those have gone far beyond. Well and far beyond. And there's a reason why they're in a lawsuit for defamation. Now, Clayton could have easily gone after her for defamation on all of this. What it was is that he wanted to make sure that his name was cleared of all this garbage that was coming out. Now, she's the one that stalked him. She's the one that pursued him. She was the one that, in not just this case, but in a few other cases, claimed basically the same damn thing. And then claimed, you know, turns around and claims, oh, well, I lost a child. Oh, I had an abortion, or any number of things. And it wasn't for money. I mean, money happens, but that's not what most of that was about. Most of that was about trying to get someone to come back to her. It's a crazy way of doing it, because of needing that affirmation. And that's where some of those similarities happen. Without Jeremy being around, you see that it gets very quiet because he doesn't give her any attention. If you don't think that they're still not filming to make sure that they're protected, then you're a little bit out of your mind. This whole going after Jeremy in this kind of way is not healthy. As you'll see from the way that this reads out. When a trial judge considers ex parte evidence, such as anonymous social media posts made after a hearing which are not admitted in evidence, and the court makes an adverse factual finding based solely on that extrajudicial evidence, is the judge obligated to recuse? And if recusal is denied, is that subject to her harmless error review, which requires a separate showing of actual prejudice? Or is it structural error requiring automatic reversal without any further proof of prejudice? A judge can recuse themselves if they believe that there happens to be a reason for them to recuse themselves. Okay? Now, they're trying to say that the trial judge in this case had considered ex parte evidence, such as anonymous social media posts, after a hearing which are not admitted in evidence. Well, if she's going out there saying horrible things outside of court, then yes. If people are showing the evidence that she's doing those kinds of things after the judge has said stop, then yeah, that very easily could be. But from everything that I've seen, this judge has applied everything according to what was seen in court. A judge can look at what's going on outside of the court and make up their own mind as to what's happening. They're not under the same scrutiny as a jury. So material facts is a whatever issue purely a question of law. Did the trial court apply the wrong legal standard when it ordered Laura to pay $150,000 in sanctions? No, because there was sanctions for her shenanigans. And this is the same thing that you're going to see happening in, well, and hopefully whenever somebody's doing some shenanigans in the Hales case there, you're going to see sanctions being thrown up against, what is that? Oh, that's a mark on, I was like, is that something on my screen? Right up here at the very top. You can't see it, but at the top there's a little speck, and it's just part of the 3. And I thought there was something on my screen. I thought, what the hell is that? You're gonna see that the judge, because time's ticking for what it will be, not this Thursday, but the following Thursday, you're gonna have the judge say, okay, we're moving this case forward. Do you have an attorney? You don't have an attorney? Then we're moving forward. If you do have an attorney, we're moving forward. Because if you're going to wait until the very last minute for this person to sign their name in there, they're wanting to, the judge wants to move this case forward. And of course, today, someone's response is due. Actually, a few people's responses do, if I'm not mistaken. Now, this is where it starts getting really touchy, is because these fools believe that they can just go ahead and willy-nilly file stuff using the same rules, using the same anti-slap rules, and they're about to find out how fast that gets slapped down. I am sure that this judge isn't going to be too happy, everybody trying to copycat each other, and how it applies to them whenever there's different burdens of standard that they have, different standards that they have to follow. When it was ordered for Laura to pay $150,000 in sanctions for filing a pleading that violated Rule 26 without following any of the procedural requirements of Rule 26, it shouldn't be a question, it should be a statement. See, this right here is ridiculous. Why would you put it in there as a question? Resolving this question of law involves no factual disputes. Even if every adverse finding of fact against Laura is true, the lower courts still erred as a matter of law because they misapplied. Oh, everybody misapplied. You were just wrong. This court has never interpreted the Rule 26 safe harbor, but countless federal courts have done so in its federal counterpart. Decades ago, in 93, a federal civil rule was amended to add a safe harbor exactly like the one in Rule 26. And in the ensuing years, federal courts have consistently held if the safeguards of Rule 11 are not followed, sanctions are unavailable. This is true even if the underlying pleading was frivolous. We must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Arizona trial courts concur. The Rule 11 sanctions are not available to a party that fails to strictly comply with the requirements of safe harbor. And unpublished authority cited for persuasive value. I love that. Unpublished authority cited for persuasive value. Great. Because the error there was procedural legal, the facts are essential, irrelevant to the question. 226's application, however, some background detail is helpful for such context. As such, a condensed summary of the facts is offered. Background: a 2-hour evidentiary hearing was held on June 10th, 2024, and the transcript is provided in petitioner's appendix as Exhibit B. The basic facts come from that transcript. Laura claimed on May 23 she had one night sexual encounter with Clayton. 11 days later, Laura took a test that showed she was pregnant. Clayton denied sexual intercourse occurred, but he initially acknowledged there was sufficient other sexual contact that pregnancy was a possibility. He acknowledged that there was sexual contact, that it was a possibility, because any time that there is any sort of contact, there could be. You know, it's one of those kinds of situations where he never stuck it in, but there was enough contact that she still could have. But because this is the Laura Owens case, Stacy. This is Stacy. This is Laura Owens. I cut out. I'm pretty sure. Say Rule 26 one more time. Yeah, Laura Owens. Laura Owens. I had Patty at the top of my list, but dropped her when the amendment doc was filed. Both Daves then moved to the top. We'll see. We'll see. If you guys are wondering which Dave it is, Dave's not here. It's gonna be fun. Watch it. Everybody spurg out. Yeah, I can only guess that people were spurging out last night. I can only guess. I don't know. I went to sleep last night after I got done laughing my ass off. Which Dave is it, man? Dave's not here. This is gonna be hilarious watching them spurg. I am sure that it is going to be ongoing today. Laura claimed on that one having a one-night sexual encounter where she supposedly got pregnant after swallowing. Months after the case began, with both parties proceeding pro se, in mid-December 2023, Clayton retained counsel who accused Laura of fabricating the pregnancy. Well, now see, you're jumping ahead here, Gingras, because it was much more different than that. Didn't she have an attorney filing documents for her? It was representing her on a limited basis, only for one particular portion. And that attorney wasn't representing her. And that right there got him in front of a judge where she kept rubbing her fake belly bump, an alleged fake belly bump, because she wouldn't have been pregnant at the time. And all of that was brought in. So not only did she lie multiple times, and that's why she's being charged, is for her lies. That's why she's being indicted. You've already lost the appeal, like multiple times. What's Gringy saying now, Nanny Goat? Well, he's trying to claim that months after the case began in mid-December, Clayton retained counsel, but this was after a couple of hearings, and whenever people saw what was going on, he did a really good job of asking questions, of maintaining himself pro se, and there were so many people that were concerned with what was happening in that case that they actually, if I'm not mistaken, crowdfunded and told him, you need to have an attorney. I think Dave Neal was heading up on that. That old judge fell for her lies. Yeah, that is correct. Yeah, the fake belly, supposed miscarriage in July, court appearance with fake baby bump in October. Explain that, Laura Owens. Yeah. Months after the So in mid-December, he finally got counsel who accused Laura of fabricating the pregnancy. Clayton's counsel threatened to seek sanctions under Rule 26. Days later, Laura retained counsel, and on December 28th, 2023, Laura invoked the Rule 26 safe harbor by moving to dismiss with prejudice. In her motion, Laura explained petitioner is not now pregnant with respondent's children here. There is no paternity. No, that is not how it happens. That's not how it happens. You have to understand, they threatened to seek sanctions under Rule 26, and she was moving forward with this already. The safe harbor part was already over. Here, there is no paternity or maternity to establish this petitioner is no longer pregnant. According to this case, it must be dismissed. She was never pregnant. She is yet to prove that she was ever pregnant. Ever. You've got her lying. And this is why she is in court, because she lied and said that she was knocked up. She lied and said that she had lost both of the children. She claims that she went to Planned Parenthood and had this ultrasound done. She lied and lied and lied and lied and continues to lie. And that's why she's in court, why she's going through the court system right now. And they are not playing around. Who wants to bet the cops found a fake baby bump in Ella's closet? That would be hilarious. Despite Laura invoking Rule 26 of Safe Harbor 6 days later, on January 3rd, 2024, Clayton moved for sanctions under Rule 26. That motion cited no other authority other than Rule 26 as grounds for sanctions. Well, that would be Clayton's attorney that did that. Clayton's motion failed to comply with Rule 26's new procedural requirements in multiple ways. Just the new ones. First, Clayton failed to provide the written warning required by Rule 26CB. Second, he failed to attach a copy of the written warning to his motion because no such warning was given. Third, Clayton filed the motion before the 10 business day safe harbor period required lapse. Fourth, Clayton filed the motion despite Laura promptly doing exactly what the safe harbor permitted. Oh, I can't wait to see the response on this one. The trial court found that Laura's petition violated Rule 26. Despite this, the court held compliance with the safeguards of Rule 26 was not necessary because fee sanctions can be ordered under other authorities, and those other authorities do not have the same safeguards as Rule 26. Court of Appeals affirmed that logic. Oh, yeah. Such facts relevant to structural error. After receiving the trial court's post-hearing ruling, Laura noticed a key factual finding was not based on any evidence admitted at trial. Rather, a finding appeared to have been copied from social media posts made by an anonymous third party on the internet after the trial concluded. Specifically, the summary of the trial testimony of Clayton's medical expert, Dr. Samantha Deans. The court made the following findings. See, Dr. Deans testified that Planned Parenthood does not accept anonymous patients. This was during the court hearing. Okay. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification. She further testified that Planned Parenthood is not open on Sundays. When petitioner testified, she sought care on July 2nd, 2023. The specific finding that Planned Parenthood is not open on Sundays was attributed to the trial testimony of Dr. Deans, but as the trial transcript clearly shows, Dr. Deans said no such thing. What? What? Yes. Was it Dr. Deans? I'm trying to remember, Dr. Samantha Deans, because I believe, it was Clayton's medical expert, and she did not. If I'm not mistaken, she said no. Well, and that would, okay, that is correct. She further testifies that Planned Parenthood is not open on Sundays. I believe she didn't mention that. That's pretty true. That he is correct in this. This was something that she did not say. I watched that back, and what she testified to was they do not accept patients using alias. Patients are required to provide a government-issued form of identification. And according to what the judge filed was saying, that it was the judge that put that in there. Now, is a possibility that the judge already understood how Planned Parenthood worked, and there also might have been something mentioned about this before they even got into the trial. Because you have to remember, we're not privy to what testimony was given before the judge called everybody into court, because there were certain things on there. They're waiting on Rule 96. Okay, John. Very cool. Very cool. Upon seeing this, Laura filed a notice of change of judge for cause, arguing that the trial judge's review and consideration of the extrajudicial evidence social media posts published on the internet, but she never claimed that that's where it came from, was sufficient to show bias and prejudice within the meanings. The presiding judge denied Laura's notice, concluding with essentially no explanation that these facts failed to show by a preponderance of the evidence that Judge Mata's finding that Planned Parenthood is not open on Sundays reflects bias or prejudice against petitioner. The presiding judge also found any misconduct was non-prejudicial because the issue of Planned Parenthood's business hours was of little to no importance given the rest of the findings in the July 17th ruling. Exactly. Now, there would have to be something very specific about that, because this is the hill you want to die on, Greengris. I mean, I'm serious, because Planned Parenthood, whether it is open on Sundays or is not open on Sundays, it doesn't matter. They're saying they don't do these anonymously. They're saying you cannot come in there anonymously, and there's safeguards that Planned Parenthood has. Those safeguards are to ensure that they don't come back and somebody comes back and sues them. Also, so they can make sure that they track that person in case that person comes back later and wants to sue them. But there's no proof she ever showed up at Planned Parenthood. Doesn't matter whether it was Sunday, Monday, Tuesday, Wednesday, or any other day that ends in Y. She never showed up there. It was too far-fetched, and she could never provide any sort of proof of that. Unplanned Parenthood, yeah. These findings were affirmed by the Court of Appeals, which rejected Laura's argument that the judge's review of extrajudicial evidence constituted structural error requiring automatic reversal. That is not true. While a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias apart from any structural error claim, that critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or deep-seated favoritism. But it didn't look like there was any of that either. The appellate court concluded that Laura failed to meet this standard and that the issue of Planned Parenthood's business hours was not prejudicial. Well, in reaching these conclusions, as explained in front of the Court of Appeals, misapplied Arizona law and made the same legal error that was reversed by the Kentucky Supreme Court. But you're not in Kentucky, you're in Arizona. Finding review of extrajudicial evidence in a family law matter, well, that doesn't matter. Constitute a structural error requiring automatic reversal without any showing any prejudice. Required reversing Court of Appeals decision which held harmless error review apply. Reasons why review should be granted. No published Arizona decisions controls the point of law. This point of law. Rule 26 is essentially brand new in family court. On August 30th, 2018, this court ordered sweeping changes to those particular rules. This was the first overhaul since family law rules were created in 2006. This change was so significant, Respondents Council even shared a helpful article about it, observing the update was needed to confirm those rules to modern usage. And that, okay, doesn't matter. As an Arizona, and so you're quoting somebody else that has nothing to do with this? Okay. The article notes what purpose the change was to conform those rules to modern usage. When it changed the rules 6 years ago, this court fundamentally altered the process for seeking and avoiding sanctions in family court. Unfortunately, because Rule 26 is so new and because it contains requirements not present in the old rule, it replaces there is no published authority from this court or from the Court of Appeals interpreting the safe harbor requirements of Rule 26. That lack of guidance allowed the lower courts in this case to severely misunderstand. Oh, she's so misunderstood and misconstrued. Oh, she's misconstrued. Miami Vice. Oh, Miami. Time's a ticking, gonna be there soon. I can't wait to meet you finally. Oh, it's gonna be great. That lack of guidance allowed the lower courts in this case to severely misunderstand, misconstrue this new rule. This court has never spoken on the issue of Rule 26, a safe harbor. It should do so now, and you must do it as soon as you can. This case involves important questions of law, which were incorrectly decided. The lack of any published authority involving an important new rule is reason enough to grant review. But another reason, good reason exists. The Court of Appeals decision was egregiously wrong. The Court of Appeals flatly ignored more than 30 years worth of federal case law interpreting the now substantively identical federal version of Rule 11, which Rule 26 was expressly modeled after. Indeed, the Court of Appeals refused to even discuss any federal authority supporting Laura's position, concluding wrongly it was not well grounded in fact or law. Clearly, the opposite is true. Indeed, the Court of Appeals errantly affirmed using the logic and process of the outdated, now abrogated Rule 31. That error was directly invited by Clayton, who improperly cited outdated Rule 31 authorities such as Grow v. Grow, the case decided before the 2019 rule change. Because of that invited error, the Court of Appeals improperly ignored helpful and plentiful federal cases interpreting these rules, which are functionally identical to Rule 26, and refusing to accept guidance from the federal courts. The appellate court also departed. It's everybody else's fault. It's not Laura's for, swallowing. It's everybody else's rule for making up these horrible rules. All these rules we've been violating. So horrible. So horrible. Stop violating these rules. But this is how it goes. To help shed light on Rule 26 in her appellate briefing, Laura cited extensive federal case law describing several key aspects. Doesn't matter. Different rule, different. Oh, okay. Well, more crying and whining. Laura cited extensive authority when holding the party rules. See, he keeps wanting to say these two rules are identical. They're not. They're different rules. Hide the frying pans first time, Shizzy. Oh, my God. To the extent Clayton cited any responsive authority at all, it only further supported Laura's position. Well, her position was, if I'm not mistaken, was down on all. Never mind. Oh, choke on that one, Laura. The exact same as Aaron present here. The trial court imposed $150,000 in sanctions for fees which Clayton incurred. No, he incurred them pretty damn early on. And see, they keep making up these little hypotheticals right here. Hypothetically have been awarded under authority does not change the result. Here, Clayton actually threatened Laura with Rule 20, and he actually moved for sanctions. Those are the facts, not hypotheticals. Okay, applying Rule 26 correctly, the moment Clayton threatened sanctions, the rule gave Laura the absolute right to withdraw her petition within 10 business days. No, it doesn't matter whenever he cites it. This is what the appellate court found. Laura should know positioning is everything. That's right, Danny Goat. She should know. She should know better. By refusing to allow Laura to take the safe harbor, the trial court did exactly the opposite of what Rule 26 was adopted to achieve. But see, here's the problem. She did not end her filing correctly, because her filing was to claim that she was still pregnant. And what he said was, you need to withdraw all of this and make sure that you say in there that I am not the father of any child because no child existed. And whenever they refused to do that, he brought it in court. And this is whenever all of her lies got brought out. So all of her lies got brought out in court. Every single bit of it got called out. But the Gingras couldn't handle that. I am so surprised that Gingras didn't get himself in trouble for his actions during that hearing. I am so surprised that the judge didn't throw shit on him for doing that. From the commencement of the time that Laura was moved to dismiss to the extent Clayton incurred any fees, how could he ever incur any fees? Well, in the lower courts, they misapplied everything because they're always so damn wrong. Why are they wrong? Well, they're just damn wrong. We can't have them being damned wrong. I mean, a little wrong is okay, but damned wrong, that's just too much. Now, see, he's wanting to quote another one about another case involving a family court proceeding in which the trial judge considered extrajudicial evidence regarding the criminal history of a party. An intermediate appellate court held judicial misconduct involving review of ex parte evidence is subject to harmless error review requiring proof of prejudice. Just as this court should do, the Kentucky Supreme Court did. What? It's Kentucky Supreme Court. This is a different court altogether. You lost on appeal, and it really hurts. I mean, it really pinches, doesn't it? So here, without any discussion, the Court of Appeals rejected the Kentucky Supreme Court's holding in Marchese. In doing so, the court also misapplied Arizona case law. No, because Arizona case law is different than Kentucky case law. And they don't have to follow every single bit of it. Gingrey, nobody gives a flying F. And then, of course, this was him that wrote this on May 29th, 2025. They should order supplemental briefing and oral argument and should reverse the judgment below. His chances of getting this are pretty hard. His honestly getting this is going to be pretty pretty damn hard. They don't have to hold oral arguments. They can look at it and say no. And I'm looking at this to make sure that I don't have anything here, because we'll be going over the decision of the court. But before I do that, I need some more coffee, and I'm going to read you a nice little letter. It's going to be fun, and I hope you're looking forward to it, because this is going to be Billy Badass.
Sandy shores, get a tan, Rambo the orangutan. Driving a golf cart, oh man, Rambo is half crazy, yes he can. Well, that SOB's a sight to F and see. Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Whoa, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is, well, that is too dirty to say here. Shizzy on the dunes, coffee in hand. Rambo is a loon, and Shizzy is that is too dirty to say here, Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Otters in the surf, hummingbirds in the sky. Rambo honks the horn and spits in Shizzy's eye. Oh my! Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having an effing blast. Oh, Rambo's rolling. Rambo takes a turn, driving to the wave. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Rambo takes a turn, driving to the waves. Otters wave their paws, telling Rambo, not sure, but if you could understand, Otter, it probably wasn't nice. Oh, Rambo's rolling, rolling, rolling. As the sun, he's free at last. While Shizzy has his coffee, these two are having a effing blast. So here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too. Well, here's to Rambo, otters and hummingbirds by the edge of the ocean. And Shizzy, well, he might just be there too.
Oh, yeah. And you know what this means? This means it is that time. I'm coffeeed up and I've got, oh, I don't have it on this one. Well, let me get it on this one because I know I have it right here. Let me do this for you really quick and make sure that it happens. Here we go.
It is about time. Let's break this mother down. With Shizzy, Whiz, Nut.
An open letter to Laura Owens and Attorney Gingras. When spin meets felony, the Laura Owens Delusion, Esquire Edition. Dear Laura, and most especially you, Attorney of the Year, in your own delusions, Mr. Gideon S. Gingras, you've done it. You've actually outdone yourselves. Just when I thought we'd reach peak absurdity with Laura's podcast policing, TED Talk tear-jerking, chicken soup sob fishing, and people are tracking my every movement paranoia, here comes a verified petition for special action, so performative, so constitutionally confused, so nakedly desperate, it deserves to be carved into marble and displayed in the courthouse lobby under the plaque that reads, "Warning, not how law works." And let's be clear. This wasn't written for the Court of Appeals. No. This was drafted with the intention of success. This was drafted for a performance, a press release in waiting, a future talking point on some soft-lit YouTube interviews where Laura can once again flutter her eyelashes and claim she was denied due process by his court, while holding up a document that, if any had more empty legal calories, could be served with Cool Whip and a side of tears. This verified petition for special action, let me pause to appreciate the choice of verified, because nothing screams, I swear this isn't a tantrum, like slapping that word on a Word document. This is a 30-plus page homage to every kitchen sink legal cliche the internet has ever birthed. You took what is essentially you being mad about losing a family court and tried to spin it into constitutional emergency. A landmark violation of sacred rights and a cinematic injustice so egregious that only the appellate court could restore the balance of the universe. Petitioner alleges a lower court error. Translation, the judge ruled against me and I didn't like it. The commissioner acted illegal, arbitrarily, and capriciously. Translation, I don't understand the ruling and I assume the corruption must be involved. Fundamental rights were violated. Translation, I Googled constitutional bug words and duct taped them to my whining. You didn't file a special action. You filed a judicial Yelp review. But this time, she brought back up, Gingras, you actual legal mosquito. Let's start with you, Counselor Gingras. I'm going to use the term counselor very loosely here if we use that word without offending actual lawyers. Moonlights as paralegal at a discount tarot shop. The drafting style suggests someone took a paralegal certification course via Groupon and then asked ChatGPT badly to make it sound urgent but fancy. Well, because this filing reads less like the work of a licensed professional, more like the third semester moot court dropout trying to impress his parole officer. You wrote a petition dripping with constitutional theater and zero legal substance. Every page screams, I read part of a con law textbook once and now I think I'm Clarence Thomas, if Clarence Thomas had a Tumblr blog and a drawer full of adult coloring books. You throw around terms like arbitrary and capricious, violations of equal protection, and in excess of jurisdiction like confetti at a pity party. But here's the thing, words mean things, and in a courtroom those things have to be backed up with actual law and facts, not the fever dreams of a client who thinks she's the main character in a true crime docuseries. You can't just spray it on like Axe body spray and hope the court swoons. And that whole in excess of jurisdiction thing, honey, unless Commissioner Spencer grabbed the gavel, kicked in the courtroom door and started ruling on maritime law, you're going to need more than a thesaurus and a righteous indignation. Do you genuinely believe the filing met the bar, or did you think the word verified was a cheat code? Well, this is not verified, this is valorized. It's you and Laura standing on the deck of the Titanic with a keyboard and shouting, I speak unfair. And Laura's fantasy and Gingras's ink, and let's unpack what you two tried to do here. You took a run-of-the-mill family court loss, a ruling you didn't like, and tried to dress it up as a constitutional apocalypse. You framed Commissioner Spencer as some rogue judge who denied Laura her fundamental rights because she followed procedure and ruled based on evidence. You claimed that Laura's rights were violated because the court dared to hold her accountable for filing a paternity case and then abandoning it mid-scandal after she miscarried but still wanted to retain control of the narrative and the defendant. All of this hinges on the idea that feelings equals legal harm, that if Laura feels wronged, there must have been due process violation, that if people on Reddit are saying mean things, then the court must have enabled her harassment. If Clayton Eckerd talks about a public case, well, lock him up and hand her a Pulitzer. It's a legal equivalent of crying fire in a courtroom because someone burned your ego. You lost. You filed a case, tried to drop it, played PR victim while dragging the court through your emotional landfill. And when things didn't go your way, you ran to a higher court with your hands in the air like an injured soccer player begging for a yellow card. You even managed to accuse a judge of bias without a shred of actual evidence, unless you count she didn't agree with me as evidence. You do, you clearly do. And rather than accept that you were held to the same legal standard as anyone else, you've decided that you, Laura Owens, curator of the TED Talk temper tantrum, mother of the misunderstood miscarriage case, patron saint of the restraining order misuse, were targeted by a grand conspiracy of judicial injustice. Well, it's laughable and sad and laughable again. Mostly laughable. Special action, more like special effects. The special action is supposed to be reserved for extraordinary relief, not for clients who want to run a judicial GoFundMe campaign to litigate their public humiliation, and humiliation seems to be her kink. This petition isn't an appeal. It's a press release with footnotes. And your extraordinary circumstance seems to be my client made a mess of everything, blamed the judge, and now wants a do-over without paying the piper. Other words, she wished she hadn't swallowed. Laura Owens' misuse in a court process and got called on it. She tried to control the media fallout by painting herself a persecuted truth teller. Now she's hiding beyond your keyboard like it's a riot shield. But Gideon, baby, if this is your shield, it's made of wet cardboard and borrowed outrage. I love how I call him Gideon. Let's talk about the commissioner you smeared. The real gall here, that really gets me, is how you two casually assassinate Commissioner Barbara Spencer's character in this filing. You don't prove misconduct. You don't show evidence of bias. You just simply imply it over and over again like it's a TikTok trend and hope the Court of Appeals won't notice that your entire case rests on a fact that your client didn't get her ever-loving way. She ruled, you lost, that it's not a violation of due process. That's called Wednesday in courtrooms across America. You made this snake pit, and let's not forget Laura's own role in manufacturing the very scandal she now wants judicially erased. She filed the paternity case, went public with it through TED Talks, social media, and sympathetic interviews, attempted to drop the case, but still publicly commented on it, accused others of stalking, harassment, and worse, with zero criminal charges to support her. Then had the gall to claim that she was the one being silenced. Gingras, if you think this is the kind of constitutional violation that the appellate court should entertain, then I suggest you look up the phrase frivolous filing and start prepping your own motion for sanctions, because this is not just embarrassing, it's borderline unethical. You claim you were maternally harmed? That's cute. Was your TED Talk canceled? Did your chicken soup for the soul stop returning your emails, or was this just another chapter in your performance art series, How to Weaponize the Legal System While Playing the Victim of Soft Lighting? You keep referencing rights, due process, equal protection, the Constitution, like you're defending a whistleblower on a war tribunal, and you're not. You're complaining that a judge ruled on your case using evidence instead of vibes, and now you're flinging legal spaghetti at the appellate wall, hoping one soggy strand sticks long enough to give you one more chance at TikTok relevance. Well, the final verdict is this. The petition is toilet paper manifesto. It's a legal tantrum, a shameless attempt to paint Laura as the hero of a story that she set on fire, a cosplay of the constitutional law written by a man who ought to know better but clearly chose not to. You didn't write this file to win, you filed this to whine. So here's my suggestion. Take this verified petition, roll it up, store it next to Laura's TED Talk DVD and a box of unsold chicken soup anthologies, because that's all this document is worth. Comfort food for delusion, written in legalese and delivered to a court that will no doubt see through it faster than Laura switches narratives. This isn't a special edition, it's a special delusion, a desperation filing dressed up in constitutional drag, complete with emotionally charged nonsense and passive-aggressive footnotes. You didn't file a petition, you wrote a manifesto for people who think court rulings are popularity contests. And to the nameless hack who helped draft it, if this is your idea of persuasive legal writing, please do us all a favor and pursue a less harmful career path, like flavor text writer for expired salad dressing labels. Sincerely, Shizzy Whiz Nut. First of his name, courtroom clown wrangler, still smarter than this filing, with a helmet on backwards and mittens clipped to his jacket.
It is about time. Let's break this mother down. With Shizzy, Whiz, Nut.
Ah, yes, so much fun. I had a blast reading over that. Now you're wondering what I'm doing on the days that I don't stream in the mornings. This is the kind of stuff that I do whenever I'm not streaming in the mornings. Laura Owens, what a twat. Oh, I did see something in here. I believe it was earlier. Oh, Rickles, it says, you have an email. Green tea. Sounds like Rickles wants to start some more stuff up with me. Well, Rickles, I've got news for you. I cannot be contained. You can try. You can try. It's not going to happen. I will put injury onto you. I will make it so much fun. Thank you very much, Rickles. I will check out that email. I don't know if I'll be able to get a response to it because my week is about to go absolutely bonkers crazy. But we'll see. We'll see if I have time in between all the other crap that's going to be happening this week, because it is going to be absolutely crazy. I'm just saying, it is going to be so crazy. You guys have no idea. And I've got to go because I think there was something up here earlier today, earlier in the stream, which comes in very first that I don't want to miss. And that is from Hippie Witch, where she became a YouTube member once again. Thank you, Hippie Witch. This is for you.
Welcome to the shit show. Every single day.
Yes, every single
A
day.
new flavor of fuckery.
'Cause everybody sucks, you see, and they're dumber than a bag of twats. Monday, Tuesday,
Wednesday, and then 4 more days of increasingly stupid, ridiculous, ignorant,
Boulder, Dash, Poppycock, Bollocks, and
fuckery. Yeah, it's all over again.
Oh, yes. Look at this, man, right there. Connie Carlson, you're late. You might need to make sure you're not pregnant with twins. No rush. You time it as I see fit. Oh, buddy, I'm telling you, if it's what I think it is, we're going to have a blast with it. We're going to have such a good time. Oh. Dollywood bound. Yes, I will be Dollywood bound. There will not be a stream tomorrow morning, of course, but we very quite possibly might have a stream tonight. I know that MG wants to do a men's stream tonight, but you have to understand, MG. You have to understand. There's new filings coming out, so I'm gonna I'll have to have a talk with MG about that. We'll confer later, sir. We will confer later, because if what I think is coming out, it's going to be absolutely good. It is going to be absolutely wonderful. And I dropped you the invite if you want to stop in this morning. Wish I could go to Dollywood. Well, there's always another one. I'm pregnant with what? I didn't swallow my lunch. It was just another lunch date for her. Let me have dinner, a movie, and 2 of those. Oh, you too late about that. Oh. Now, it's really interesting because my grandmother was a twin. She was a paternal twin. There was a boy and a girl, and they were both redheads. And people don't know that much about me. They it's like I don't really have an aversion to redheads. I just understand them because I was born into a family that had redheads. They're dangerous. They're creepy little things. They got these little fingers, and they poke at you. They got sharp teeth too. Yes, soul suckers. Oh my gosh, you're gonna love this. You're gonna love this because there's only one kind of soul sucker that you can get. In case the lightning doesn't give it away, it's Vol Storm.
Thank you. Pronounced correctly, spelled correctly. I help. By the way, MG's wanted to do a men's stream. Does he not realize we got to go pick up Baker tonight? We don't have time for this.
Yeah, there's very little time for that.
Dollywood week, people. That means schedules have been completely upset.
Yes, all schedules.
It's here,
are
folks.
Off.
It's here.
Yeah. Like my stream tonight, if I'm able to get through the whatever filing is coming in, because there's a time limit on getting that filing in. Right. If I'm able to read through it and understand it before I write my damn letter, then I'll do a stream tonight about it. If not, then it might just be like tomorrow.
Well,
like if I have time, then,
write it like everybody else does.
You mean I just cut copy paste?
Yeah. Just copy paste. Have AI write it for you. You know.
Yeah, exactly.
AI never does anything wrong.
Never makes a mistake.
No, man. No. Baker has been on planes, trains, and automobiles, and he will be here in the glorious valley that is East Tennessee tonight.
Yeah. Yes.
And hopefully he doesn't have to hitchhike to Knoxville. But, you know,
true.
You got to do what you got to do.
That's true. What is it? 10, 11, or 11:10?
Yeah, something like that. I don't know. I just know he's showing up.
Yes. Easy peasy. Yes. It's gonna be interesting. It's gonna be interesting. See Baker in 3D. I'm looking forward to it. Looking forward to seeing Miami too. That's gonna be really good. Yeah.
Yes.
Oh.
I can't wait to see everybody, especially folks that showed up last year that are coming again this year, and then all the new faces that are going to be coming in. It's going to be, God, I'm so excited. I'm so excited.
I am too. I'm just like the time is coming. I mean, whenever I told the wife, I was like, it's Tuesday that I'm leaving. She goes, oh, I've got to get a different notary to come in on Wednesday then.
Oh,
I was like,
she probably has like a whole army of notaries. What is she worried about you for?
Well, she has a whole office of notaries there.
Yeah.
Then she has to find somebody to witness it because it's a closing. So,
yeah.
But and of course, then what I'll do is I'll probably just have her scan in the documents, and then I'll separate them out for the closing so I can file all the correct deed work and shit like that.
Yes, that'll take all of 5 minutes.
Yeah, it doesn't take very long. I just I've done that before where, you know, I just take all the documents and then I sort through them and go, okay, this doesn't need to be filed. The options agreement has to be filed and this has to be filed.
Right.
It's super easy. Takes me no time at all, but I can do that remotely.
Exactly.
Oh,
but
yes.
No, man, it's here. We're here. It's go time.
I mean, yeah, Sunday after we finished up, we were having a conversation. MG was just like, oh God, I got you, MG. No, it was, you know, we were talking about, yeah, let's go over and see MG after this. And then we started talking about getting stuff set up. It was like, oh my gosh, just so much going on that we
Well,
just totally missed it.
and prayers to MG on his groin surgery this week.
Yes. You know, there's it's those pelvic moves. See, MG's got these pelvic moves. You ladies don't see this because he's always sitting down, but he's got pelvic moves that just overextended his groin.
Again, 2 years in a row. We're still not sure Shizzy's going to be here.
I was on a Valhalla's stream before I went live last night. I went in there and I said, "Hey, who's that hottie right there?" And he ignored it until I put in there, you know, the one with the dreads. He was like, he said something. I said, I'm already started walking. What are you talking about? he goes, that's going to take a long time. I was like, long legs, short body.
That's right. That's right.
I'm
Yeah.
low.
Yeah. Shizzy should have started walking 2 days ago.
If I was walking. No, I've got to pull all kinds of stuff out that's going to be picked up and take a picture of it for curbside service of picking up all the trash. We're allowed 2 of those a year or something like that. So like big stuff, like I've got some box springs that need to go and a easy chair came out of this place we remodeled.
Yep.
Yeah, it's crazy the amount of stuff that I have to do before I leave, and then I got to meet with somebody this morning. I think at 10. That's going to be interesting too. Oh, MG, I wouldn't start until Expert and Baker at the Waffle House. Oh no, it's going to start before then.
Oh no, it starts before then because I don't think people realize the prep work that has to go into this. Now, granted, we already went through it last year, so we have an idea what to do, but there's still stuff that has to be done before Baker gets here.
Yeah, you have to prepare the red carpet for Baker.
Oh yeah,
yeah. It's one of those where it takes a while to roll it up into your car. So whenever he comes walking out of the airport, you can roll it out for him because he demands that kind of service.
Well, and plus you've got to. Baker's so picky about what he wants to eat, so you have to prepare all that stuff ahead of time. He only prefers the fine eateries like Wendy's, Taco Bell. Possibly McDonald's.
Moon pie shakes.
No, it's funny because when he gets here to the States, because they don't have fast food over there, not really. That's what he wants to eat when he's here.
It's like I have enough home cooked meals anyway, and it's usually like cardboard and fish.
Right. But we're like, damn it, we're taking him to Waffle House. He's seen too many videos.
Yeah, Waffle House is going to be much better than any fast food he could possibly have. It's fast food done slowly.
Yes.
And plus you get the attitude.
In a casual, just sit down environment where everybody's cordial. And
well, I don't know. I don't know about your Waffle House. I don't know about your Waffle House, but our Waffle Houses are not cordial. There are some vicious, angry women that are PMSing really hard.
Ooh, Lord.
It's like who in the hell is your cornflakes this morning? Because you've got an attitude, lady. I don't care if it's 3 o'clock in the morning. You're the one working that third shift. Not my fault.
It's not my fault. You had to come in and pick up third shift.
I remember getting those calls. They didn't like it.
Unless you get the right amount of tips, you're not going to be getting a carton of cigarettes this week, honey.
Gee, yes, the injuries are my wife's fault.
See.
Oh, yep. He's correct. He is correct. Those injuries are his wife's fault. But just remember this.
That's why
sticking your 2 fingers like this and and then place your thumb on top like so. That will increase the pleasure.
Exactly.
Exactly. I love it. That's sure.
Absolutely not sure. We might have to take care of that as well. When you get that box of freshly hot donuts with the glaze is literally dripping off of it. Oh, there's nothing
yeah.
like it.
Yeah.
Nothing
Because
like it.
that Krispy Kreme is like, oh, so good. Ah, yes. Does the Cheesecake Factory sell onesies? Hey, Nick, you could have come too if you would.
We actually our expert actually took him to Cheesecake Factory last year. And believe it or not, there were he tried a few different cheesecake recipes, and there was actually a couple he likes. So don't let Baker tell you he won't eat cheesecake. It's not true. It's not true. We have video evidence.
He goes, but there's no cheese in there.
No.
Pizza with everything. Yes, nanny goat. That's right. That's right. No, if only Clayton Eckerd would have taken that to heart. I mean, you know, nobody invited Nick. You were too invited to Dollywood.
Nick, you had an open invitation just like everybody else. Don't give me that.
You just decided
it's not like you don't know where it is.
Yes.
You were here last year. Granted, it was after Dollywood, but he was still here last year.
Oh, it's not my fault that you're not a Krispy Kreme fan. I mean, that's entirely up to you. If you
I'm not sure we can be friends now.
Yeah, if you eat cold Krispy Kreme, that's your own damn fault. There was a place here in Atlanta. They actually had two places. I can't remember the name of it off the top of my head, but they would do nitrogen shakes or Yeah.
I've heard of that.
Okay. So one of their flavors was Krispy Kreme.
Oh.
And so imagine you get this like really cold, delicious shake. I mean, just like their whatever flavor you got, it was going to be wonderful. And you get that first taste of it, and it's like you just bit into a Krispy Kreme, except cold. Like the flavor is so perfect. I was just like,
oh, that sounds so good.
Oh, I mean, it was melting in your mouth. Oh, so just like, yeah. I just imagine a Krispy Kreme shake. Like the flavors were all perfect.
I'm still hungry from y'all talking about Waffle House last night. Damn it.
Yeah, look at that. Says, hey, Nick. Nick says, I got an open invite to Houston last year and nobody else went.
Well, but you showed up here and everybody was here. So I don't care about Houston.
Except for me. I was sick.
Well, I was sick. He never shows up.
Well, Nick was just like, hey, let's go to the Bigfoot museum. I was like, oh, that sounds so awesome. I was like, this would be an easy drive. Go up, hang out with Nick for the day. Oh my God, I was so sick. I was running a damn like fever, and I was like, the last thing I need to do is get Nick sick, and it would be my fault that he never makes it back to Sweden, or is it Sweden or Switzerland?
Finland, Netherlands. It's all the same area. They can call it whatever they want.
Place where those Vikings are from.
It's the same damn people. It's the same damn area. It's cold and they speak some weird language. Every single one of them.
It's just you faked the goof. I did not fake the goof.
Dude, he always finds an excuse not to participate. That's why I'm like, I don't think he'll show up for this.
No. I actually have to pack my bags tonight so I can be ready to walk out the door in the morning. Hopefully I can go get my haircut before I leave.
Oh, I'm doing that tomorrow. I'm getting my haircut.
Yeah.
Nice.
I'm going to get a nice facial massage. Not a facial massage.
Well, that's a departure from your usual.
get a haircut, facial massage. My back gets rubbed. It's wonderful. It's like you know, an all you can eat buffet. Hot fresh glazed donut. Baker would love it. Yes, he would.
Yes, he will. Yes, he will.
No, that would be incorrect. Kaiser has pictures of him and I, and so does Laura Needy. Yeah.
That didn't really happen. He just wrote a chapter of that in his book. He didn't really meet Shizzy.
Lawrence would help with that Shizzy. I bet she would like to.
Be afraid the donut get her pregnant.
Probably. She got glazed.
And then she'd sue Krispy Kreme.
She sued Krispy Kreme because she looked like one of the calendar girls. It's like she needs to eat some Krispy Kreme. That's all I'm saying. She needs to choke some of the things down. At least eat some meat or something. Good Lord. Well, not that. I mean, I guess she tried eating meat, but
well, yeah, that's what started this whole thing.
Sheila, they eat smelly fish. Oh my gosh, you guys are killing me. The whole world is AI, and I'm just another NPC. Does it feel like that sometimes?
Walks around, has a certain dialogue. That's it.
It gets freezing.
Yes, Tanya, Mo will be with us.
Yes, Mo.
She is coming in. It's gonna be fantastic. We're gonna be able to reunite what I have termed the Canton Triangle, which is Baker, Valhalla, and Mo.
Oh yeah, I can't wait to see how all that works out, because it's gonna be crazy watching him, Mo, and Valhalla all having to stream the same thing, and they'll be basically in the same place. That's gonna be interesting.
I can't wait to see. It's like, you've seen Mo, you've seen her show, you've seen the snark she brings.
Oh,
I can't wait to see it in person, not on stream and just unhinged.
Yes.
That's going to be, see, that's the great thing about coming to these things is, you know, you get to see all of us in person, unhinged, and not having to worry about YouTube restrictions.
I know. Because we are very restricted on what we can say.
You have no idea.
I would love, I'm so excited to see Mo just like unhinge on these people.
Mm-hmm.
It is going to be just absolutely glorious. And she's probably going to have a hard time streaming whenever she does. She's going to be like, damn it. I said
Friday morning, hungover Mo.
I don't think she'll be hungover. I think that she'll contain herself. I think she will. You know, if not, we have a place for her. Mo has a library of isms. There's probably a bunch of F-isms, like, are not giving it F-isms.
Mm-hmm.
It's gonna be great. I'm so looking forward to this. Oh, I've seen Mo.
And you're welcome, because people screw up my name all the time. It's Volstrom? No, it's Volstorm. That's the way it's spelled. As we tell Baker all the time, English, it's pronounced exactly as it's spelled. Come on.
I honestly thought it was Volstrom in the first place. You know, because I don't pay close attention.
Yeah, but you're in the R word, so.
That is true. I do ride the short bus and have a glittery helmet.
You do have a glittery helmet. Yes,
God, this thing has gotten so, like, there's hardly any spot left on this thing. I mean, I've even got
that thing has turned out fantastic, by the way.
It has. I think I've put Rosalind's to shame. I mean,
I don't know. We'll have to compare them in the light.
That's true, because Rosalind will be there also.
Don't take directions from Bo. She got us lost in a 200-yard paved road.
I saw that. Mo in final form Jesus.
Yes.
Oh yeah. Oh yeah.
How do you know Mo is not final form Jesus?
Could be.
I'm just saying.
Just saying. Have you ever seen him in the same room?
Nope.
Nope.
Can't say I have.
Can't say.
Can't say I have. It's like you've never seen me and Batman in the same room. Just saying.
Does Rosalind have a bigger helmet than you, though? Well, she might. I guess we'll just have to compare helmets, won't we?
She might. I mean, that's only because of head size, though.
that's, you say Rosalind has a big head?
I'm saying you're short. That's all I'm saying. It's gonna be funny carrying a midget shizzy in a backpack.
Oh, it'll be at least a rucksack,
Right.
You
gotta touch helmets.
Without, yes,
that
yes.
is not something we promote, MG.
If Rosalind brings her helmet, we will touch helmets. Georgia fan. Well, hey, at least we win.
Not anymore.
Well, that's true. That is true. Novice helmets are larger.
Novice helmets are true.
Wait, Rosalind has a helmet? Yes.
Oh yeah, she has a helmet. It looks like a
disco ball.
Disco glitter ball.
Yeah. It is. It is hilarious.
I'm like, if she's out riding a bicycle and you can't spot that, there's something wrong with your eyesight. Seriously.
Oh God. Yeah. Well, something might be wrong with your eyesight after you do spot it. The way the sun hits it, you'd be like, God,
I'm blind. That's the real reason Expert has to wear sunglasses, is because he was blinded by the helmet.
Partially. That and Rosalind's beauty. I mean, it is so deep and so far.
Yet another crude joke I can't make on YouTube.
Yep. But she does
far.
deep so far. Don't tell your wife you're comparing heads with Rosalind. No, helmets, heads, not helmets.
Hey, she don't watch this show. We're not worried about it.
That's true. She doesn't watch the show. Actually, people I know, in 3D world don't tend to really watch the show.
You think I tell people I know I'm on these shows? No.
People go, so what do you do in your spare time? I do a little bit of this, a little bit of that, mostly reading.
I have so much stuff to do around the house. I don't have time for that kind of stuff.
Never. There's never any time. I'm just another, bobblehead that wanders around through life aimlessly, no purpose. It feels so good.
So good.
But she does have a purple one. Not sure. Good to see it. Well, everyone, I'm gonna throw you over to the dogs. And actually, it's much better than that. It's going to be Mo in the deep end, and pretty soon they will be more Karen Reed. I wonder how they're doing that without Baker.
Marissa's running it. Marissa's running the show while Baker's out, just like last year. So what's going to be funny is when Baker gets back and they're automatically in jury deliberations.
That will be funny because that'll be his luck too. That will be his luck. They'll be in jury deliberations. Oh God, I totally
best part of the trial,
that.
he won't even be there.
I know, and he'll be there for like closing arguments, but he won't be there for jury deliberations. Just like, you son of a bitches, why did me? All right, everyone, we will see you very soon. Hopefully tonight, but if not, well, you just got to enjoy it. See you soon.
Peace.
Let's get started. good.
Why they stopping me? Stopping me.
I'm as excited